Yeah, I'm stacking them, yeah, yeah. Riding with country bass, country bass. Yeah, I'm stacking them, yeah, yeah. Riding with country bass, country bass. Yeah, I'm stacking them, yeah, yeah. Riding with country bass, country bass. Yeah, I'm stacking them, yeah, yeah. Riding with country bass, country bass. Yeah, I'm stacking them, yeah, yeah. Riding with country bass, country bass. Yeah, I'm stacking them, yeah, yeah. Riding with country bass, country bass. Yeah, I'm stacking them, yeah, yeah. Riding with country bass, country bass. Yeah, I'm stacking them, yeah, yeah. Riding with country bass, country bass. Yeah, I'm stacking them, yeah, yeah. Riding with country bass, country bass. Yeah, I'm stacking them, yeah, yeah. Riding with country bass, country bass. Yeah, I'm stacking them, yeah, yeah. Riding with country bass, country bass. Yeah, I'm stacking them, yeah, yeah. Riding with country bass, country bass. Yeah, I'm stacking them, yeah, yeah. Riding with country bass, country bass. Yeah, I'm stacking them, yeah, yeah. Riding with country bass, country bass. Yeah, I'm stacking them, yeah, yeah.
Yo, yo, yo. Happy, what's today? I don't even know what time. Whoa, it's Wednesday? Happy Wednesday, everybody. Bitcoin Chris checking in yet again. Once you leave the fiat matrix world, you start to forget the days because there are no days, right? Happy Wednesday. Bitcoin Chris checking in. Head over to swanbitcoin.com/Bitcoin Chris. Get $10 free Bitcoin if you have not yet. Get your fold card. Link is in the bio. Today's episode, of course, we're going to jump into the Bitcoin price, the Bitcoin price, the Bitcoin price, and we're going to jump into how to settle all debts yet again. Even though I made like two videos about this again, but I'm going to show you guys the actual case law. And if you guys want help with this, then you guys can, reach out for help. Or if you're being sued or you want to sue, and these are services that I provide and would love to help you guys out with as well. So, with that being said, let's jump into the Bitcoin price, the Bitcoin price, the Bitcoin price. Right now, we are looking at the 4 hour time frame, and we are right at the 0.25, which is 111. We came down to the spot that I did mark out the last live that I did create. I know it was probably like a 2 3 hour, almost 3 hour live, just doing a bunch of stuff, including TA. But here we see it came right down to where I said even down lower, which is another 107 um, support line that was drawn as well. So, yep, look at that support, resistance, support. This was your support up here, support, broke down. So here we're back at the next level of resistance, which was support. So we'll see, we can either reject here, retest that, and then head down lower, or we could break out, probably come back down, retest, and then head up to the 118 level that it was already drawn here on my chart from the highs to the lows, which would be 120. Where is this one actually? Yeah, it should be up here. Let me ensure this is correct here. Yep, from the highs to the lows. You have 118 as your target. Um, I think I deleted one of my other targets, one of my other emojis here because it hit. And so because it hit, I took it off. Or we can go into that video and check it out later on if we need to, but I don't need to do any of that. Boom. So as you can see here, I don't have market cipher B on, so let me go ahead and put that on. All right, we do have money flow starting to get into the green. We do have red dot up here. We are pretty high up. Let's go ahead and go out a little bit more. Look at the daily. Okay, daily looking good. Yesterday was a good day. Again, we found our support here. So 1 2 3 touches here. Green dot on the first started to pump. So that looks good on the daily. That means the weekly must look a little bit better. There you go. Weekly definitely looks a lot better. Was not looking good. If this can continue to turn upwards, let me make sure my audio is good. So that way I'm not chatting away and nobody can hear me. We're not going to take too much time on the TA today because, again, I want to show you guys how to settle your debts. Hit that like, share, subscribe. I know it's early. Chatting away and nobody can hear me. All right, cool. Audio is Gucci. So make sure you hit that like, share, subscribe. Thank you guys for tuning in. I know it's early. I know I usually don't even stream this early, but I want to go ahead and knock this out. I got a lot of work to do, paperwork to do, lots of filings to do, lots of things to do. So I'll share with you guys a couple things as well that I'm working on, as well as what I've been doing, and specifically with Accord of Satisfaction, in regards to settling your debts and obligations. But let's continue. 2 hour time frame. We're gonna zoom out here. 2 hour time frame. We do have a green dot here, but we're looking like we're starting to maybe come down a little bit. But we do have money flowing to green here. If we zoom in a little bit more, we have red to green, money flow increase. That means pumpage. We do have momentum shifting up, coming back down. Maybe this will move back up. Short term, 2 hour to me does not look too good because of this. Maybe we come down a little bit more and then it come back up. But we're gonna have to wait and see, right? Again, there's only two things that's gonna happen. We're gonna go up or down, right? Or maybe three things that can happen, right? We can go sideways, we can go up, we can go down, right? So here I think we do pump up. I could be wrong, but we could come down. Again, I've already given you guys the actual potential movements here. But here we have on hourly, we're going to keep going down. Hourly, we're looking, money flow is good in the green. We have 4 o'clock in the morning, we had a green dot. Came up again to this spot here and this is just resistance right here. One, two, three, four. If we, well, every time we hit a resistance, right, it should get weaker and weaker. So maybe I think we do pop out here. Let's go down to 30 minutes. 30 minutes, we have a green dot. Everything looks like it's coming down though. Let me 15 minute. Look at that. This could turn around though, especially since it's 10 o'clock. Or Wednesday's probably not too good. Drew a flag here, played out, dumped. Look at that. That's your automatic entry candle. From there, pumped. Now we're just consolidating. So I think we do head higher. I don't know what I just did there. Boom. I think we do head higher, but we're going to have to wait and see, right? So that's your 15, 30, 1 hour, 2 hour, 4 hour. We did daily. 4 hour looks good now. Looks like another red dot just popped up. Green dot, sorry. Green dot just popped up 8 o'clock this morning. So I think we're good. I think we had higher. So next target 114. That would be my next target for a trade. If I did open up a trade from here, that would be 2.3%, 20x leverage. That's 40%. Basically, 40% of 1,000 is $400. 10,000 is $4,000, right? So there you go. Of $100, that's $40, right? That's your opportunity. I would risk $400. I would risk what? Half a percent times 20 is 10%, right? Risk 10% to make 40%, basically, right? Boom, as an option. So that means risking 1,000 to make 4,000, right? As an option. My math could be wrong. I don't really know, and I don't really care. You guys can do the math on your own. Just giving an example. Boom. All right. So now that we're looking at BTC, I think we're done with that. Let's look at DXY real quick. We'll look at Misty and MicroStrategy, and then that'll be it. DXY coming down. Good. Assets should pump now. With that being said, we're still holding up this support level here, or which was previous resistance. Oh, yeah, support. And we have support here. And we have support here. Let's zoom out daily time frame. We are just looking bear flag. It's just like a massive bear flag on the dollar, which makes perfect sense as we all know that the dollar is trash, and the more they print, the less value that it has, despite these notifications or reportings of inflation going down lower. Look at that. That'd be crazy. When's the last time we came down here? May 2021, December 2020. I think this is when everything freaking dipped on this crazy rip. All right, so I can expect us to, if we lose these levels, then it'll take some time to get down there, but that could be potentially. Excuse me, your Tarjay. Well, weekly looks like it could head up. We're gonna have to wait and see, right? I don't know what's gonna happen. We just have to wait and see. Misty, real quick, jump into that. Misty looks like it gapped down to 16. Wow. We had some buys at 19, 18. Now we get a discount 15, 16, 17, 18. Okay. Look at that. I said this could be a reversal, but it broke down. Boom. Came back, retested, dropped. Came back, retested again. Drop, drop, gap down lower. So we could definitely fill this gap. So 16 is in the future. What are we on? 2 hour? Let's look at the daily. Boom, we have our 3 consecutive green dots. I think we're at a low here. I was expecting something like this here, but it's not as defined or well structured. We definitely hit the stop loss here that I had here. So let's close that out. Let's close that out. So your new low, because now we have new lows, right? We got to redo the fibs. Highs to the low. And now we have a target of 1 8, oh, sorry, target of 34, up 118%. Possible opportunity for Misty is what I would be looking at. Again, this is a cash flow vehicle. You're not supposed to be using this for anything else than cash flow, right? And unfortunately, when you buy into these type of assets, they can go lower, but also they can't go higher. But as long as you DCA, or you know what's going on, or you understand the reasoning behind you actually getting this asset, then you don't have to worry, right? Because you should still be cash flowing. That's all that matters at the end of the day. 3 green dots here. We're looking at the daily. Let's look at the 4 hour. Looking decent. 2 hour was looking not too good, but we have a green dot here. Our green candle for the last 2 hours. For Misty, let's look at the 1 hour. Money flows in the red. So just be cautious. Let's look at MSTR. And that'll be it for today's TA. We're here at the 20 and 200. Broke down a little bit. Now we're starting to recover. We either break up or we're going to break down. Okay, so again, only 2 to 3 things that can happen. We're either going to chop around sideways, we're going to go up, or we're going to go down. Okay, so MicroStrategy still a great buy. Obviously, we're looking. Let's zoom out a little bit here. 4 hour, excuse me, 4 hour time frame. Let's see. Yep, lows, boom. Okay, still at the lows. Again, I'm looking for a 408. Well, first one will be 376. then 408. First target 376, second target 408 for MicroStrategy. If we can head higher, if not, we will head lower. And the potential, is that a trend line? What line is this? Let me zoom out a little bit more. What line is that? Yeah, that's your weekly trend line, which is that black line there. Um, hmm, I think we go. I think we go for it. Look at this, a green dot on the daily. Yeah, man. I think we go, man. I think MicroStrategy about to go, man. And you guys already know my target for MicroStrategy is 1500 or 1300 or 1400. Okay, about 1400. So it's not about if it's going to happen. It's just about when it's going to happen, right? So shout out to MicroStrategy. If this is an asset class you're into, good for you. All right, so that's it. Excuse me, that's it for today's TA. We're gonna jump into now the settlement of your debt obligations. Okay, so now we're gonna jump into the law, the law of the land. All right, cool. So let's jump right into. Let's jump right into. All right, cool. I want you guys to read. So we're gonna be going over this case here. This is one of my filings, so I'm going to go over the filing with you and play a video for you. And then we're going to also read the actual law as well. Or, yeah, the law again. So here we have Burke Company versus Hilton Development Co. Right? Actually, let's go to that actual case because this is not going to actually. Actually, I don't have that case pulled up. So what I'll do is I'll come here and then I'll go up to here. We'll look up these as well. Let me just copy that. All right, we'll move those over there. Boom, boom, boom. All right. All right, here it is. my bad. I'm on another. I'm on these. I'm searching for these other cases for us to look at as well, in conjunction with the what's this appearance. Yikes. Let's go. I found it. All right, cool. I'm excited because again, this is not even this one, but the other two that I just pulled up. So, anyways, let's dive right into it, right? A lot of you are in debt, right? And debt is something that we are occur by default because we're in a debt-based society, right? And so throughout the last, year that I've been teaching or learning and teaching a little bit about what I've been learning and applying what I've been learning, right? So we are in a debt based society. So by default, we're going to accumulate debt and have to have debt. Debt is credit, credit is debt. We're in a double bookkeeping entry system. We are in a bankrupt system, whether you know it or not. When they took us off the gold standard, they didn't allow, we didn't have the ability to settle any debts. This is why when I say you can't pay a debt with a debt note, that's pretty accurate, right? Because that's only going to incur more debt, right? So by law, you would have to redeem it in lawful money, which is 12 USC 411, which we're not going to get into in this actual video, but that's very powerful to redeem everything in lawful money because we don't have the lawful money. The United States has the lawful money because they took the gold and silver. So you have to redeem your Federal Reserve notes, your bills, whatever it is that you have, contracts, all that good stuff, right? In lawful money versus the debt based currency that we're using now because you guys think that the dollar bills that we go to work for is money. It's not money, it's currency. So with that being said, let's continue. I currently am in a ton of lawsuits, right? I'm currently litigating and suing tons of people or corporations. It's not people, actually one person, and then the rest are corporations. So these people are getting sued, right? Because again, like I've been telling you guys since the beginning of the year, or even last year, this is the year of the lawsuit. So we must learn and implement and strategize and utilize and enforce our rights. Because if you don't, you will not have any rights. Because, or if you don't use them, you don't have them, pretty much, right? So, with that being said, one of the cases that I have is in regards to accord and satisfaction, right? And accord of satisfaction basically means if there's a dispute or they call it an unliquidated claim, which I asked chat here. We're going to go through, how I use chat because I've already been telling you guys since I think I've been using chat for 2 3 years now. Not exactly sure how long I've been using chat, but it's been a while now. That if you're not utilizing the artificial intelligence to your advantage, you're falling behind. So, these things are not new to me, but they may be new to you. So I want to encourage you to utilize these things and to double check your work as well, right? Double check chat's work. So here we are. A court of satisfaction means that you have a bona fide dispute or an unliquidated claim that you are. So a bona fide dispute means you don't agree with the bill. So for an example, let's just say your car note, right? If you have a car note or if you have rent payments or whatever, or your credit card debt or a loan, right? Any debt that you may have or incur, right? If you don't agree with the amounts owed, right? You can send a dispute in regards to that actual account. Once you do that, that is called a bona fide dispute, right? You don't agree with the late charges, you don't agree with the principal amount, you don't agree with whatever the case is, whatever the amount is, whatever it is, as long as you have a dispute in, then that counts as a bona fide dispute. Once you have a bona fide dispute in, then you can do what? You can send in, aka tender, a payment on a negotiable instrument, which is just a check, money order, promissory note, bill of exchange, et cetera, right? And you can write on that note or instrument, I'm sorry, negotiable instrument, you can write for full and final settlement, right? Once you write these things on the negotiable instrument and they cash it, that is a new contract. And once they cash it, it literally extinguishes the debt. Okay. So That doesn't mean that they're not gonna try to come after you, right? Or do anything to you, right? So that's the whole point of this whole entire live is for you to see the process, explain it a little bit more in depth because I've actually gone through it. I'm actually doing it. I'm actually in litigation right now. It's public information. So these are public laws. This isn't anything secretive, right? But again, we don't know the law. We don't know our rights. So if you don't know what's going on, then how can you do anything? How can you move on anything? How can you correct anything? How can you enforce anything if you don't have the information, right? You don't know, just like I've been telling people since 2020 to leverage your business credit to buy Bitcoin and to get a business so you can cash flow to take care and, offset all that good stuff, right? Just because you don't know that you can do it doesn't mean that you can't do it or that it's not possible. So, with that being said, let's continue. This particular case is something that I sent a notice of to my case because the case is actually still pending, and I'm waiting for the judge to make a final decision and whether or not he, decides in my favor or not. I have case law. I have the law on my side. So you have to know how to appeal. You got to know how to do all these things, right? So, anyways, this specific court case is Burke Company versus Hilton Development Company, and this is in 1992. So this is a few years after I was even born. So a lot of these things are happening before we are even born. A lot of these things are happening back in the day when people actually had to learn and go to the library and all that stuff. And they didn't have ChatGPT or the World Wide Web to help them access this information readily. Readily. Uh, quick, quick. Quick update. Bitcoin is just now pumping, pumpy, pumpy. All right, so here we go. I'll give y'all a break. We broke 112. So again, next target 114. Just wanted to give you guys a quick update on that. All right, back to the money. All right, so this case, you guys can look it up yourself. We're going to look it up here. We're going to read it. We're going to read it here. I actually uploaded a screenshot of the actual case, and I told chat to look it up because I don't got time to be looking things up like that. So chat looked it up for me, and I said yes, because everything is according to the Universal Commercial Code, and every state has the UCC, their own version of the UCC codified in their laws, right? So boom, here it is, case law, or the case focusing on accord of satisfaction, which is what we're talking about, and it aligns both with common law and Florida UCC. The Burke Company supplied construction equipment to, and just for, this is only for educational, entertainment purposes only. I'm not a lawyer. I'm an attorney in fact. I'm not an attorney at law or practicing law I don't practice law. I know the law. I study the law. Whatever the case, whatever the proper terminology is, that's what I am. Okay, I'm an attorney in fact. Okay, I don't practice law. I study law. I know the law. They expect you to know the law. Your ass should know the law too. Whether you think you should or not, you definitely should. And if you don't know the law, that's why you're in the position that you're in now. I digress. The Burke Company supplied construction equipment to Hilton Development under a rental agreement. After a dispute over unpaid rent and missing damaged equipment, Hilton Development issued two checks to the Burke Company, each stating on the back that it was endorsed. Endorsement is how you sign, right? Endorsement. We should you guys follow me. You guys should know about endorsements by now. If you don't, look it up. Would acknowledge full and final settlement of all sums owed. If you write down full and final settlement on the check, as I just mentioned before we even started to read this, and you have a bona fide dispute or it's an unliquidated claim, then it's a new contract. One moment, please. Give me 1 second, guys. Thank you for holding, guys. Appreciate you. Back to regular schedule programming. All right. After the dispute over an unpaid rent of missing and damaged equipment, Hilton Development issued two checks, and again, they acknowledged it for full and final settlement. They endorsed it full and final settlement. The first check titled as balance. Second check crossed out endorsement with added reservation under protest. First check titled as balance. Second check crossed out. So I'm assuming. Okay, yeah. So the Burke Company, they crossed out the endorsement and added with reservation under protest. Despite the protests, Burke altered the back of the second check, endorsed it. Again, we talked about endorsement. You seen these things? Endorsement. That means signing it. And you're supposed to sign a specific way. I tell you guys the same things every time. And I want you guys to know this because it's very important that you have to sign things without recourse, without prejudice, all rights reserved. If you don't reserve them, you don't have them. And they cashed it. So not only did they alter and cross out the endorsement that Hilton put on the back of their checks, which says full and final settlement. That's why you got to have pictures and documentation of what you said. All right. They altered the back of the second check, endorsed it, and cashed it. Boom. The court held that this constituted accord and satisfaction, meaning Burke had accepted the check and final settlement, thereby discharging Hilton's further obligations, granting summary judgment in the favor of Hilton. The law is here. Okay? You make sure that it comes from just the law and not just what chat is saying. Okay? And that's what I did, right? I saw that this case was here and I said, okay, cool. Chat, explain this, pull it up, etc., etc. And it broke it down. You guys have to do the same things. Stop asking me, stop asking people. Ask ChatGPT, ask Google, verify, cross reference, ask Manus, ask Perplexity. Get all three of their answers, compare and contrast, put your brain, read it for yourself, and then come up with an educated answer, right? And an actual answer based on the information that's provided, based on the facts of the matter, not based on my opinion, your opinion, what you've been taught for the whole time that you've been alive, because everything that you've been taught is a lie, whether you want to acknowledge it or not. Let's continue. Hit that like, share, subscribe if this is something that you find valuable. If not, that's okay. I'm only here to help you. I can only lead you to the water. I can't make you drink. I've been telling you about Bitcoin since it was 3 grand. They were at 113 grand, 112 grand. It is what it is, right? I can't make you guys do anything. I can only help you guys to see the information. I can't make you do anything else. So let's continue. Accord means an agreement to settle dispute by giving or accepting something in satisfaction of a claim. Satisfaction means performance or execution of that accord. Once the check was cashed under full and final settlement condition, the prior claim was legally distinguished regardless of the protest. Right? So Florida UCC section 673.311, sorry. Florida UCC codifies accord of satisfaction. Florida UCC codifies accord of satisfaction by the use of an instrument. So it's in code, Florida law, under section 673.3111. Your state has the same exact code, not code, but same exact, universal commercial code codified into your state, so it will be a different section in your state. But for Florida, this is the section that governs this actual law, right? The debtor must tender a check as settlement in good faith. The creditor must negotiate, deposit, or cash that check. There must be a conspicuous statement on the check that states that it's full satisfaction of the claim. In Burke, all elements were met. There was a dispute. The debtor must tender a check as settlement. in good faith, creditor must deposit or cash that check, and there must be a statement on it. So, because all those things were met, the check was tendered in good faith with clear, full, and final settlement language. Burke cashed the check, extinguishing the claims because they tried to sue them for more money. But because they understood the law, Hilton Development Company, they're slick. They said, "All right, we know the law." This is what I'm saying. Like, if you know the law, I'm not saying to do anything. I'm not telling y'all to do nothing that you're not supposed to be doing. Okay, so that's not what this is for. This is for you to understand the law. Whether you think it's right or wrong, that's nor here nor there. Learn the law. If you see something like this, just don't cash it. You got to be smart with it. Actually, you're still SOL because UCC says that if you dishonor, then if you dishonor unlawfully, which means they made an attempt to pay and you didn't even accept it, then that means that the obligation is discharged anyway. So to be honest with you, you better hope you don't have somebody smart like me and now you who understands the law, because again, we're going to touch on that in just a moment. Regardless on if they cash it or not, the obligation is discharged, and I'm going to show you guys how and why in just a moment. Let's continue. As cited by secondary sources, simply put, the creditor cannot have his cake and eat it too. Once the creditor accepts, negotiates, which means deposits or cashes a check marked full satisfaction, they cannot pursue further claims. To invoke or void a court of satisfaction under Florida law, obviously you have to do what we just learned about, right? So, boom, I had it help me do a notice for my actual case because I already knew this, which is why that's why I'm already in litigation in the first place. But I asked it to tell me more in the search for more Florida laws or appellate courts that I could, or more case laws that I can look up. And I don't even like using case law from ChatGPT at all. But I didn't find the first case law from ChatGPT. Again, I was able to find that through another video, doing some research, and then I was like, all right, screenshot that case actually, and then have ChatGPT look up that case and explain it to me. So I hope that's making sense to you guys. Boom. So now let's continue. Again, if you got loans, student loans, if you got house loans, if you got car loan, if you got credit card, if you got you can do it with rent, you can do whatever it is that you want to use it for, to be honest with you. So it's really up to you. But you can use this. Boom. So I said, give me some more case law. So here we have St. Mary Hospital versus Brinson, which I actually looked up. And then we have Martinez versus Bayshore Tower LLC. So we're going to look those up. And I don't think these two are actual cases, which is why I said make sure that you do your research and to see which ones are verified. I said, hey, make sure these are verified, and if so, provide other links. So they weren't able to provide the links for the other two, which is great reason, which is the reason why I said you have to do your research. Don't just take anything at face value. But St. Mary's Hospital versus Brinson is a real case, and I looked that up here on Google, and then here's Martinez versus Bayshore. And so we're gonna jump right into these two things. Next, I hope you've been taking notes. Write some things down or come back to this actual video later on and see how we can help you guys out, right? Third District Court of Appeals in Florida. This is 2008. Opinion filed March 5th, 2008. Martinez versus Bayshore Tower. Oh, this is Martinez versus Bayshore. Right? This is not even the other one. Same hospital. We'll look at the hospital one in just a second. So this one is for the Bayshore Tower. So which one is this one? Let's go back here real quick. Boom, boom, boom. Share this one instead. So this one shows that found that a check marked full payment and negotiated under dispute amounts to court and satisfaction, which is exactly what we're talking about, right? So here we're going to go back up here and read this one. It says Martinez tendered a check with full payment in full notated on it. The payee cashed it, but tried to continue enforcement. The payee's acceptance and negotiation, which we looked up, is depositing or cashing of the instrument was binding court and satisfaction. The statute codifies the common law rule that acceptance of a check offers full payment extinguishes the claim. So now we're going to go back, right? Because that was the synopsis, that was the quick breakdown of it. But again, we're going to look it up for ourselves. As I just said, this is just Steel Law. This is the real website. As you can see, this is not Slapjack's opinion, right? This is the real deal here, filing, right? So Martinez versus South, boom. Martinez, South. An appellant judge from the Circuit Courts of Miami, Florida. This is Miami-Dade County. This is in Miami, Florida. Boom. Let's read down where it says the developer and the purchasers enter into a pre-construction condominium contract, and the purchasers gave the developer a 10% deposit of the total purchase price. Thereafter, the developer abandoned the project. The developer returned the purchaser's deposit with a letter stating that cashing the check would serve as a court of satisfaction, terminating the parties' rights and obligations under the contract. All the purchasers, all of the purchasers cashed their checks. The purchasers contended contend that there was no intent to settle an existing dispute and thus no accord of satisfaction. Developer asserts that there was an accord of satisfaction because the purchaser re-levied, re, 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 relied, relieved the parties of all rights and obligations under the contract by cashing their return deposit checks. We agree with the developer. The accord of satisfaction results when the parties mutually intend to effect a settlement of an existing dispute by entering into a superseding agreement, and two, there is actual performance in accordance with the new agreement. Compliance with the new agreement discharges the prior obligations. Ooh, we gonna look that up right there. Boom. We gonna ask chat about that right there. Boom. Let me just get that over here real quick. All right, cool. Let's continue. Where we at? We're just okay. Boom. Here, cashing the checks satisfied the elements of accord and satisfaction. So this is not me telling you this. This is the law, and this is an appeals decision. Y'all see this up here? Florida, Third District of Appeals, 2008. All right, so here, boom, let's continue. It showed that the purchasers intended to effectuate a settlement of dispute and also constituted actual performance. Performance is payment. Did you guys not listen to what I said earlier? When you perform, actual performance, performance is payment, payment is performance, payment, performance, same thing, of a new agreement. Additionally, if an offer clearly serves as a court of satisfaction and the other party accepts the offer, then he or she is bound to the conditions attached. Look at that. They bring it up. We getting. I need to probably. I'm probably gonna file another. I'm probably gonna file some more. Um, I'll probably file some more notices. That's what I'll probably do. I'm reading this. This is the first time I'm reading this along with you guys. I read it obviously, but I didn't read through it. I just went down to the bottom because I just wanted to see the final judgment, right? So I didn't read all the way through, and it's not even that long of a read. I just know that the everything's at the bottom for the final decision. So boom. I'm gonna add these probably to my actual case, and I'm gonna show you guys what I did as well. Boom. Had the purchasers intended the developer to remain obligated on the contracts, then they should have not cashed their checks. Had the purchasers intended the developer to remain obligated under the contract, they should not have cashed their checks. They should not have cashed their checks. Further, strong public policy. Hmm. Supports the use of accord and satisfaction. Accord and satisfaction is a convenient and valuable tool for resolving disputes informally without litigation. It would be unjust to allow a party to accept a check as accord and satisfaction and then later permit that party to sue under the same rights and obligations that the court of satisfaction was intended to release. The person cannot have his cake and eat it too. Accordingly, we affirm the final summary judgment. Boom. And I'm actually about to download this and I'm going to add this to the case myself. Mhm. You see the power of reading and finding out what's really going on. And this is over. Oh, this is almost 10 years ago. This is 2000. Wait, this is over 10 years ago. This is almost 20 years ago. I am I the only one that thinks 2008 was is 2018? Um, right? Am I the only one that thinks that time is just like skipping? Anyways, downloaded that. We're gonna look up these two other things that we just looked put into Chat GBT as well. So let's read it. Let's read together, court class. And a court of satisfaction results when the parties mutually intend to effect a settlement of existing dispute by entering a superseding agreement. We just read that. Boom. It reinforces that you must clearly express your intent to settle by writing full and final settlement or redeem the lawful money. And it demands actual performance. You delivered, they cashed it, or retained the instrument. That's performance under Florida law. Once both elements are satisfied, your obligation is discharged. Plain and simple. All right, the second one is this one. When a debtor makes an offer clearly stating that acceptance of a payment constitutes full settlement satisfaction, of a claim, and the creditor accepts and acts on that offer, the obligation is discharged by a court of satisfaction, even if the creditor doesn't fulfill all conditional duties. Specifically, the debtor tendered payment with a condition attached, full satisfaction. The creditor cashed it and partially performed, but did not complete all post conditions. Still, the court held that because the terms were clear and the tender accepted, the original claim was extinguished. So, if an offer clearly attaches that the condition that the offer, if taken at all, must be received in satisfaction of the claim of the dispute, and the other party received it, he takes the offer subject to the conditions attached to it, and the offer operates as accord and satisfaction. Let's pull that up. Whoa, 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 whoa. Whoa, 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 whoa. We're having a little bit of a tech issue. Give me 1 second. We back. All right, so it's about to pull up. Just give me a second. Restream it be acting crazy sometimes, but it's all good. What is the same one? No, it's not. This one? Yeah. Another one in Florida, huh? Look at that. Appeals court of the district. See, so what you guys should be getting from this as well is that these people have already been to court, right? They went to court, they either lost or won. Um, Pretty much they probably won, or they didn't win and it needed to be appealed. Whatever the case may be, it went into the appeals court, right? And this is in 2012. So we're gonna scroll down to the bottom because again, the final judgment is at the bottom. And we can read this, but this is looking like a lot more to read. All right, cool. So let's see. Where's the final judgment at, man? There it is. So this is where they took it from. Unliquidated. There goes that word I was telling you guys about. Mm. Mm. That's crazy. They reference in this 2012 case the case from 2008. So I'm probably gonna do another note. Yeah, let me do another notice right here, real quick, man. Let me do another notice real quick with y'all, real quick, man, because this is crazy. In the appeals case, they used the case that we just uh Martinez versus Bayshore. Is that the one we were just reading, or was that? Yeah, that was Martinez versus Bayshore, right? Yeah, cool. So we gonna use it. So they use it, then we use it. They using it, then we using it. They're not gonna play with us. They can play with you if you would let them play with you. I'm not letting them play with me. Boom. All right, so let's read this. Let's read this now. So I'm just quickly reading. I was just skimming through real quick. So they mentioned the Bayshore. So we'll just read this paragraph after that. So when the superseding agreement constitutes a dissatisfaction, a breach of a new agreement must be enforced by an action on that agreement upon based upon contract law. So this is why I say contract law is very important and to know the law because the law is what you are governed by, whether you know it or not. Settlement agreements are governed by the same legal principles to other contracts. Boom. In this case, the trial court did not apply law of contracts in denying the motion to enforce. Instead, it implied principles requiring strict compliance with the offer of judgment statute. However, the offer of judgment statute and rule apply only when there has been a rejection of the offer. But because we determined that the trial court, I'm guessing in error, then in not applying the law of contracts, we do not address the remaining issues arise by Cyrus on appeal. Reversed and remanded. So they lost. Obviously they lost. They lost. They tried to appeal, and they won because we do not address the remaining issues raised by parents on the appeal. So reversed and remanded. Whatever the case may be, yeah, reversed and remanded. Whatever happened, it was reversed and remanded because of the actual facts of law. So again, I'm saying this to say, and I'm reading this to show you guys, they already went through a proceeding. They already went through litigation. The party lost or they won or whatever the case may be. Then they went to appeals, and then the appellate court makes a decision based on the facts of the law, the facts and conclusions of the law. Because again, there's a lot of courts that don't do the right thing or don't follow the law as well, which is weird, right? Courts are supposed to follow the law, but they don't for some odd reason. Or they may have an interpretation of the law, which is not factual. So with that being said, let's jump to the next one, and then I'll jump into getting my. I'm just rushing through this real quick. I'm trying to see what happened in this case because again, chat said that this was a court satisfaction case, and they said it's for like $8.3 million. Reviewing an adverse $8.3 million final judgment and arises numerous issues on appeal. We affirm on this is 1992. 19-month-old infant was admitted to St. Mary's to undergo patient surgical procedure to correct drooping eyelid. The surgery was performed under general anesthesia with Dr. Cooney administering the anesthesia through equipment previously owned and provided by St. Mary's. Apparently, during the surgery, uh, received an increased amount of anesthesia and eventually suffered cardiac arrest. Oh my God. Was placed on life support respirator and 10 days later. Oh my God. Oh my God. Oh my God. That's crazy. Sorry this happened. Damn. 10 days later, pronounced unalive. Oh my God. That's crazy. They brought a negligence action against the doctor and eventually they settled with the doctor and his professional association, thereby leaving the claim against Mary for its own negligence. Apparently, however, discovery brief revealed that sometime after the unaliving, the vaporizer used in anesthesia during surgery was disassembled by its manufacturer, which then filed a secondary complaint charging it against the negligence. Precluded offenses, close arguments that are rated for $9 million. Okay, so the trial court entered a written final judgment in favor of them for 8.3 million. So hold on, bruh. So maybe this okay, so that's good to know what happened. Wow, that's crazy. The 8.3 was for the negligence of the doctor. Oh my God, this is crazy. So let's see what chat said. What man? Hold on, chat, bro. See, this is why I said you gotta read. That's why I said you gotta read what's going on. Chat be what's going on, chat. We talking about a court satisfaction. Hold on, bro. Hold on, bruh. So rest in peace to the baby. But what does that have to do with 12 USC? I mean, a court of satisfaction. That's the question here. That is the question that we are left to answer here. Because Seems to me that has nothing to do, unless they utilize it to settle any bills that was given to them in regards to the actual surgery. So that would make sense. But I want to get the right information. So let's look for the right information. Since I'm already here, let's read this real quick. All right. If they cash the check, negotiate it according to satisfaction applies. If they dishonor the check, refuse or return it, the obligation is discharged anyway. So if they cash it, you win. If they dishonor it, you still win. But you got to do certificate of dishonor. You got to do affidavit of tender and dishonor with proof of mailing. Court filing showing obligation was discharged. So either way, you win. Remember, I said earlier that if they don't accept it, that's dishonor, and if they cash it, that's they you win. If they dishonor it, you win. So there you go. All right, so let's go back to this damn case because what does accordant satisfaction have to do with the St. Mary's case that we're talking about here? Explicitly explain it, and if you're incorrect, state that. So I'm gonna use these three things, right? I'm going to make another notice to the judge. The notice is going to be it's going to include this case law. It's going to include this case law. And then it's going to include the no, not Mary, Martinez versus Bay South as a judicial notice. So I'm going to go ahead and do that because I only added Burke versus Hilton. I'm going to do a Martinez versus Bay Shore. I'm gonna do all that, and I'm gonna add it and I'm gonna add the document that we just downloaded as evidence or as an exhibit into the actual case. While that's loading, that's taking a little bit long here. That's taking a little bit long here. So let's go here. Let chat load up. Boom. I put this in for my notice. I said, hey, Burke versus Hilton Development Company. Boom, boom, boom. Court satisfaction. Boom. I just pretty much put in the legal authorities and just told them what's up. Right. So that is a notice. And then I did foreclosing authorities are conclusive and unrebuttable, and plaintiff's tender lawfully discharge all obligations under the lease. Okay, boom. So that's that. We're going to go back to chat now, see if it's back up. Yes, it is. Right, so we asked for the link. I was incorrect and exactly my point. See what I mean, guys? Exactly my point. You gotta read it. You gotta read it. See what I mean? You gotta read it. I'm trying to tell you. Literally trying to tell you. So that's why I said, hey, let's read it. But this one, yeah, me in there. So now what I'm gonna do is this. Boom. So exactly what I said. So what we're gonna do here is again, we're going to do another notice. I need another notice in a new Canva for boom, boom, and yeah, where you at? Where are ya? I'm looking for you, Miss Martinez versus Martinez. Martinez, where are you? Martinez. There it is. I need another notice in a new Canva for in regards to a chord and SATSFAC. It's chord of satisfaction. Um, to help seal and close case this with no questions lawfully in regards as if so boom, we're gonna do a new Canva. We're gonna do that. Um, but yeah, based on just reading what we read, excuse me, you can actually do this yourself, right? So what we're going to do here is I'm gonna go here. I'm gonna go to my videos. Actually, we're gonna go to yeah, we're gonna go to my videos, and we're gonna go to a quarter satisfaction because I want to see when the last time I told you guys about this. It's probably October, December. Okay. Ooh, where did I close? Not that deep, guys. All right. So here we have case law or the court satisfaction. But we're gonna do a certified letter, certified mailing, mail receipt Also, you can have the post office document that you sent it off as well, so you have proof. Not only will you have certified mail, but you'll have proof that you sent it out through the post office as well, which is really good. So you'll have just law here, right? And we're going to read this together because I encourage you guys to read. Typically, most people are not reading, but we're going to read. We're going to read today. Okay. Hit that like, share, subscribe. Hit that like, share, subscribe. Hit that like, share, subscribe. So let's go ahead and get the reading. Make sure ChatGPT got mine. Cool, ChatGPT is bringing me a letter. It's kind of all right, cool. So we'll check on that in just a moment. All right, cool. So make sure it's good. All right. All right, yeah. So there you go, man. Back in December, okay. I'm just gonna leave it at that, okay. Boom. We're gonna go back to chat real quick. See what chat doing. Chat still loading. While that's loading, we'll go ahead and I'll have you guys watch this video here. Actually, let me stop it so it can share the audio with you guys.
And we have yet to see what's going on because they still got a few more days left. So by the end of May, April, yeah, by the end of next month, yeah, we should have some new, another way to discharge a debt. Well, I choose to invoke my rights. So here we go. Now, I know most of you are familiar about the reconveyance of my property. If you're not familiar, just go ahead and check my YouTube. There's a video we talk about there. I'm not going to go there here, but here's another one we're doing a court of satisfaction with. Now, this is the servicer for the new mortgage on my other property, and we sent them their payment, right? Here it is, memo section. You have the restrictive endorsement. Payment in full satisfaction made on the condition that the obligation be canceled. Loan number right there, redeeming lawful money. Demand at the U.S. Treasury Department of the United States and the City of Washington, D.C., or any federal bank. Okay, that's the front. I left the number blank on this one so you could actually see. Here's the date, February this year, $28,000. In conjunction with that 789. All right. Now let's look at the backside of the endorsement. Let's see. All right. Boom. There we go. All right. Now on the backside we have by acknowledgement and endorsement of this draft, the payee acknowledges full and final settlement of all sums owed to the payee by payor on account number 316965. All right, we got that on both of them. Now, let's see if they cashed the check. If you remember from the first one, that check number ended in 0416. All right, when you look up that postal money order number, boom, post office box, the amount, view status, money order for that amount has been cashed. They were sent together, so understand they both have been cashed. So they accepted the new agreement of the terms and condition of the contract. Because prior to them receiving this money order from me, I sent them a bona fide dispute. In that bona fide dispute, it was for settlement. And I also asked them to send me an address of where they want me to send this money to. So I contended in full court of satisfaction with the restrictive endorsement. Now, they got 90 days to either send me my money back or they accepted the terms of the new contract. So they need to release any liens they have against my property. And we have yet to see what's going on because they still got a few more days left. So by the end of May, April, yeah, by the end of next month, yeah, we should have some new, another way to discharge a debt, court and satisfaction.
So I'm on YouTube and I just typed in a court of satisfaction. Let's watch this one. This is what we just watched. No, let's watch it. Shout out to Stan Strong, man. When I be telling when I be telling y'all that a lot of these things that y'all doing is fraud, the fraudulent mortgages, the fraudulent MERS, the fraudulent separation of the note and the deed, all that good stuff that you don't really understand because you're too busy working, or you think that everybody, just because everybody's doing something one way doesn't mean that's the right way, first and foremost, and that you guys don't know the law, so you're getting finessed so many times. Crazy.
Once
Hey,
again,
you know what? You know one thing you just did for me today, bro.
what's that, bro?
So I see the skill of how you're okay. You go into the case law, you're breaking down definitions. You don't let nothing fly by you, bro. And you go to it. You break down the definitions. You're highlighting the different verbs that really are the most meaningful ones. You go to the definitions, and you're connecting everything so that way we can see all the logic. You basically trace all the logic all the way through, so the thread is all connected. And this is like an infinite teaching. Like, even though it's this short amount of time, you just showed me like how to trace everything and connect it all. So it's no way you could take an L on this, bro. Like,
Okay.
if there's an L on this right here, bro, I can't see it, bro. Like, everything is connected. I'm thinking to myself, I think you did extra. You feel me?
I probably did.
This is thorough, bro. I think you did extra, bro. Like, and I'm just like, man, and he went and connected this, and he got the law. He put the state and the UCC, and I'm like, okay, dang. But I like how what you really did for me, really, is you just showed me how to just connect it, and I can now be able to continue to expand on this, and then, bro, man, like, this is definitely not going to be the last conversation we have, bro. Like, this is incredible. And I just appreciate you just imparting that to me right now. Like, I'm feeling really confident right now. And that's probably the most important thing, is just clarity and the confidence. Man, I appreciate this, man. Like, I'm about to, like,
Definitely.
because, like, now with that video, please send that video. Not to mention, if you could send me this, because I'm going to,
You got
I
it.
can
I got you.
also get any backing and look at any other case law. This is the first case law you drop, bro. It's a wrap. It's like bow. Like, it's not really, like, that's the thing. Like, I'm trying to just get to going, and you got me a way that I could just get going, bro. Like, that's what I'm just trying to do. So, like, and I also like how I can continue to expand. Oh, y'all don't got enough proof here. I could go find this. Now I know how to find case law. Now I know how to really look up definitions. These are the skills I think that you should definitely, I would recommend continue to impart to people, bro, because this is empowerment right here. It's how I'm watching how you're doing it and how you're putting it and how you're emphasizing on certain words. And I'm like, bro, this man is really trying to give the game right here.
Yeah. Yes, sir. All praise to the Most High. Yes.
Thanks, bro.
Yes,
Much
sir.
appreciated.
Yes, sir. You got any questions or anything?
Man, I just need to digest, bro. Bro. You need to chill, bro. You need to chill with that. I'm just trying to digest it, family.
Was it worth your money?
Huh?
Was it worth your money?
So yeah, man. I mean, nothing works unless you work, right? Nothing works unless you work. Nothing works unless you work. Whatever the. So nothing works unless you work it. Okay. So let's get back to it. All right. Logical application to this present case. Was my All right. Cool. So that is the actual cases. So again, you guys take the information and do what you want with it. All right. So I'm going to again, this is going to be attached to my actual. I'm about to upload this as well with my updated, with my additional supplement of notice in regards to what we all just learned today. Right? We all just we read this today and learned it, and I'm even added more stuff to the case that I've already been in since January. So we're in September. But I don't need to. I didn't really need to do all this, but I'm preserving the record on in the court case in case it needs to go to appeals, because the judge should again rule in my favor, because the law, right, it's not even about what I say, it's about what the law says, right? So I should win anyway. However, to make sure that there's no, again, to make sure I preserve the record, preserve my rights, and if it needs to go to appeal, I have my proof and everything that I've uploaded and done everything. And my case is extensive as well, so extensive paperwork. So, anyways, this is so I don't have any questions about what is actually going on. Period. So that's that. What I'm going to do now is I'm going to be wrapping up. So I want you guys to head over to my link tree. All right. So if you need help, again, if you need help or you want to do, if you are, a lot of people, so basically everybody needs this, whether you think you do or not, or you don't know if you don't need it and your friend needs it, or your mom needs it, or your brother needs it, or somebody needs it, right? Somebody needs this information, because the information is what's going to put you in a better position, right? Because if you know how to maneuver, just with this is just one way out of a few other ways to discharge and settle your obligations, right? But this is just one way to knock it out with no ifs, ands, buts about it, right? Based on the law and based on what is um, already been decided on, right? So based on the law, at the end of the day, no matter what I gotta say, it's about what the law has to say. So if you need help, if you have a loan or if you have credit card debt and you don't want it anymore, if you have credit card debts, loans, retail installment agreement for your car, you know, if you are, I think it, for me personally, obviously it's worth it to me to be able to fight for your rights, right, and do what you got to do, especially if you're struggling in financial. And first of all, a lot of people think, oh, you're not trying to do your pay your dues or pay your debts or pay whatever you like. Those people are lost. I'm not going to try to address you because you don't know what you're talking about. Um, they basically enslaved you to work for money when they took away they work for Federal Reserve notes, which is a promise to pay, because they took away gold and silver. We now have Bitcoin and other mediums of exchange that we can exchange and barter for goods and services. However, the currency of the United States which is different from the United States of America. The United States has promissory notes, we have bills of exchange, we got contracts, we got agreements, all that stuff is considered currency as well. So not just only the promissory note or the Federal Reserve note that we have that we work for, but again, the promise to pay for your car, the promise to pay for your house is the money, guys. So when you start to understand what's really going on, you automatically should want to do this and learn your rights so you can stop getting finessed and stop being a slave to the system that's making you work 40 hours a week to pay for things that's already been paid for by the United States, because all obligations and debts are United States obligations, public and private. And don't just listen to what I gotta say. Again, go look it up for yourself, guys. Like, you think it's a game? Keep thinking it's a game if you want to. You can continue to do what you've been doing, keep getting the same results, unless you stand up for your rights, start to sue people, right? Or try to do something. Do something. Y'all got to do something. So you can do one or two things right now. You can do it on your own, learn and study. You can hire a lawyer or an attorney, which is going to charge you an arm and a leg, and they have no, they're specified in their specific niche of law. So you know how you have those family laws, and you got the banking law, and then you got the civil rights law attorneys, right? You have the traffic attorneys, right? You got all your little special specific niches of law that these attorneys practice, right? Uh, versus the actual attorneys or someone that actually knows this stuff. A lot of them don't know this stuff, so I would be amazed to find an attorney that is actually well versed in this actual aspect of the law, right? So with that being said, you can do it on yourself and do it on your own. You can hire an attorney who's going to charge your arm and leg, or you can hire myself as an attorney in fact, which will help you explain the process. You can do what you do. We can help you do what you do, and the rest is up to you. We can educate you and help you draft your documents, help you draft your help you file, do everything, help you walk you through everything step by step of the way. Or you can get the course on your own, sue and defend like a pro, and do it on your own, right? And I teach you how to use ChatGPT and Manus as well to translate your documents, do everything that you need to do. Never miss a deadline. Make sure that you are responding back. How to file, uh, how to file your exhibits, and how to include that into your actual uh, filings, right? All that good stuff, right? You either gonna pay with time or pay with money. Okay, it's up to you. We want to help you. BTC is at 112,302 for the sake of you and your family, and for more BTC. Imagine if you stop paying that car bill, that car note. What happens if you stop paying that car note, and that car note, you extinguish and settle the debt obligation for the car note, because you understand that it should be credit applied to you, not debt, and that you can also discharge it utilizing lawful money, right? A couple different ways you can do this, right? So, but just for the sake of this actual example, let's just say you want to do this court of satisfaction. You make one final payment to them, right? Let's say your $500 car payment is $500, right? You send that in on a check or money order. You stop doing the automatic debit out your bank account. You get the bill in the mail. You stop getting the online bills. You get the bill in the mail. You get the check, right? You still get a check or a money order, and you mail that in, and you write full and final status. First of all, you got to tell them that you have a billing dispute. So from the start, car. This applies for everything, really. You dispute the actual bill. You dispute the amount. You dispute something. You have a bona fide dispute. You can do via mail or email. Certified mail and email, I would recommend do both. Boom. They don't respond, they do respond, it doesn't matter. You sent your correspondence. Boom. You should have your proof via email, timestamp, signature, and then you have the certified mailing, acceptance and deliverance signature or non-signature as well. So you have that. Boom. And you're going to get that money order or a check, and then you're going to write for full final settlement of the obligation, which is your car payment, car lease, loan obligation, whatever it is may be. Boom. You're going to send that in, If they cash it, it is extinguished. And why is it extinguished? Because we just read why it's extinguished. You have a bona fide dispute, you're selling the obligation. Now, instead of you paying $500 a month for your car, what you can now do is spend that $500 to buy more Bitcoin, or to buy more Misty to buy more Bitcoin, or take half of it, buy Misty and buy Bitcoin. Or you can take the whole thing, fully fund your life insurance policy. Then now you have a little bit more money into your life insurance policy. You can borrow up to, borrow that, boom, boom, boom. Now you buy the Bitcoin and the Misty, boom, boom, boom. Or now you can do whatever, right? You can use it to pay for any other things that you're drowning on, because you're probably drowning in debt anyway, because all your bills are going, all your money's going to bills anyway. So you don't have, everything's accounted for, every dollar's accounted for. Now you got some extra breathing room. Now you can go to the movies, you can treat your kids, you can take your girl, do what you got to do, but you got to be smart. And that's the reason why I said you got to invest it into Bitcoin, or, you know, DCA, or do Misty into BTC, or do the life insurance policy. There's a reason I'm saying these things. I hope you're listening. I'm about to get off here. So with that being said, Bitcoin is pumping. Bitcoin is pumping. Bitcoin is pumping. Stack your Bitcoin and shit. If you made it this far, shout out to you. I hope this is very, very helpful. Again, I went over this already, December of last year, and we looked up the laws just the NFL. We read a couple different things just to make sure that knew what chat was talking about, because as you can see, chat was wrong about a few things. So and with that being said, I'm logging out now. You guys have a great day. God loves you. I love you. Stack your Bitcoin and chill. Click the link in the bio, please, to get any help that you may need help with. Again, you can actually we can help you restore your credit. We help you with this specifically. Discharge your debts. We can do sue and defend like a pro, right? We can do that as well. We can help you. You can join the membership program, just be in the group, and chat and have access to talk to me in the private, where you don't gotta really worry about too many things that are associated with public information, public data, public companies. All right. So with that being said, Bitcoin Chris checking out. I'll see you guys in the next video. Peace. Hit that like, share, subscribe. Please share it with somebody. Please help somebody. Please help yourself. Please. And if you don't, it's all good, because I did my part. All right. See you guys later. Peace.
Yeah, I'm stacking them, yeah, yeah. Running with country bass, country bass. Yeah, I'm stacking them, yeah, yeah.
You gotta stand up for your